Daryl Wright, and David Nealon, who mostly goes by Big Country. We meet here once a month, and this is this is how we conduct our business in the sunshine as a public organization. So if I could turn to Sam, and we talk a little bit about the public comment process.
Sure. Thank you, Mr. Chair. Commissioners, good afternoon. I'm Sam Gorin, for the record, on behalf of our law firm, Gorin, Sharp, Duty, and Ezerol. This is a typical part of the agenda every month. As you know, it's called public comment, public discussion. It's governed by state law. State law allows members of the public to be heard on any matter either on the agenda or not on the agenda. I'm assuming for discussion, given the nature of the number of people today, that they may want to speak on an item which is not on the agenda regarding Dr. Chizner. Having said that, state law would permit, and you have honored that request, to allow public speakers at least 3 minutes to speak, up to 3 minutes. There's some prerogative that you may have to allow for more time, but typically 3 minutes has been both the history and the tradition of Broward Health. As you know, also, not having an item on the agenda, there's no voting item on which any commission member today can actually vote. There's no specific item on Dr. Chizner. It's public comment, public discussion. Public has a right of access and a right to be heard during a public meeting. But a couple of points of order that may help you to refresh both your recollection of where we are and where the public may choose to listen as well. As you know, in May of 2011, the federal government served a subpoena on Broward Health. It was issued by the Office of Inspector General and the Department of Justice. It was a subpoena of many pages, and it made reference to a number of physicians employed by Broward Health over the past 10 years. There are 27 doctors listed on that subpoena. At the time of the service of the subpoena on me as your general counsel, we promptly engaged, through your direction, a law firm in Washington, D.C. The firm name is Aaron Fox, A-R-E-N-T, Fox as in F-O-X, and specifically Linda Bauman and her co-partner, Jock Smith, to assist this organization with regard to what to do with the subpoena, how to handle it, how to respond to that subpoena. It is a public record and was published within days after we actually received it so that others could see it, including yourselves. So at the present time, the district is represented by special counsel in Washington, Linda Bauman and Jock Smith, who have been giving this organization advice since the service of that subpoena with regard to the physicians on the list and a review by the federal government in connection with compensation, fair market value items, and things of that type relating to physician employment with a public hospital system. Further, you may recall that in recent days, this board has actually conducted what's called SHAPE meetings, which are allowed by state law that allows a public body, a collegial body such as yourselves, to actually meet in a closed-door meeting with your CEO and your general counsel and with other special lawyers to have a privileged communication with counsel regarding anything that relates to litigation settlement, litigation matters. And on June the 4th, and on September the 5th, and on October the 22nd, you conducted 3 SHAPE meetings with Linda Bauman, Jock Smith, and myself, and with Frank Nasker, the CEO, to be given specific legal advice on a confidential basis with regard to the pendency of a False Claim Act case referenced in the OIG and the OIG's discussion for your review. So you were aware of certain very privileged and confidential matters that relate to that subpoena. Allow me to restate also for the record that, as you know, the subpoena having been issued is a very serious document. It's a very complicated matter. It's very sensitive, and good or bad, the factors that relate to it are also in a privileged confidential basis, unavailable for public consumption, much different than today's presentation where the public has a right to be heard on any matter that may be coming before you or not under state statute. Having said that, this commission, and through your administration over the past number of years, has made a very bona fide effort to work with physician compensation on the advice of your special counsel and others to bring compensation within what's called fair market value standards, as well as to be commercially reasonable for compensation over that period of time. And in doing so, you embarked on a journey with regard to the physicians on the master list on that subpoena, an effort to bring their compensation within those parameters, as you know, all public record. And in June of this year, not June of last year or whatever, June of this year, you may remember on the recommendation of the then Vice President of Physician Contracting, Laura Hunter, and of the administration, and through the auspices of outside consultants that reviewed the compensation, you did 2 things which are very important. Number one is that you approved a matrix of compensation for physicians that I think there were like 14 or 15 doctors on that list back in June, expressly to regulate within the parameters of law what the compensation could be and should be for those physicians. You also approved a template agreement. What's a template? A template is a format. It's a form of document that you as a board approved and directed administration to process in the context of offering up those contract terms with the matrix to the physicians. That was done in June. You may also remember that at the end of the conversation, staff took it upon itself to begin meeting with physicians, meeting with their lawyers, meeting with their consultants to move in that direction. To date, as far as I know, of the 14 or 15 physicians that were on the master list back in June, all of the physicians with whom you've had your relationship over a period of years have signed agreements consistent with, compatible with, in accordance with your public approval back in June, which was the template agreement along with a compensation scheme which was consistent with federal review.
It's a long meeting.
It was a fairly long meeting.
We sat there for hours and
yes,
made tough decisions.
And to the extent that the administration followed your guidance and direction, they implemented those documents. As I mentioned earlier, a moment ago, all contracts have been signed except for 2, and I can say what they are because it's a matter of public record. We're currently in negotiations with Dr. McCormick, although she's been given a termination notice, and we were in negotiation up until the end of September with Dr. Chizner. And for the record, if I can, on November the 4th, and Mr. Chair, I think we talked about this the other day, there was a letter issued by Broward Health from Frank Nask as the CEO, and if you like, I can read the letter to the record so that the public can know that this record, evidence of what has occurred, has in fact occurred. On November the 4th, in a letter that was authored by, prepared by, and assisted by our outside special counsel, both Linda Bauman and Mr. Jock Smith and Aaron Fox, along with the assistance of our local labor and employment counsel, Bruce Johnson, who's present today, should there be any questions. And the letter basically says as follows. May I, Mr. Chair?
Please.
Thank you.
We could give it to Mary Ann, Secretary, and add it to the minutes.
Dear Dr. Chizner, this letter serves to notify you of North Broward Hospital District's, that's Broward Health's, decision to exercise the 60-day notice of termination provision in Section 26 of your employment agreement, which notice is effective as of the date of this letter. As you know, we have made best efforts to renegotiate the terms of your employment agreement over the last several months in light of changes in the application or interpretation of laws and regulations that materially affect the district's healthcare delivery system and which now render your employment agreement illegal or unenforceable. This recognition was attempted in order to allow the district to continue providing healthcare services that comply with all legal and regulatory requirements and that are beneficial to the community and consistent with the new trends that have materially affected the district's healthcare delivery system. After using our best efforts, we have been unable to reach a new agreement. Therefore, the district is exercising the termination provision of Section 26. Both your clinical and administrative positions are being terminated pursuant to this letter. Your employment with the district will end on January 2, 2015. And the letter closes with some additional information which says, pursuant to Section 26 of your employment agreement, the district will continue your benefits and compensation for the 12 months period following the end of your employment. Compensation will be paid to you in accordance with the district's payment schedule with an end date of January 2nd, 2016. Your benefits will terminate effective January 2nd, 2016. This letter, as a matter of evidence and a matter of public record, was issued by the district administration in accordance with the findings that were made by this board in June regarding the matrix of compensation, as well as in the context of the format of a contract, which you also approved.
Can you explain the role of the board in the contract negotiation process and approval process?
I can. You're policymakers. You're not day-to-day operations folks that actually work in the trenches, so to speak, on a day-to-day basis with regard to the day-to-day actions of the hospital. That's your CEO. In fact, under your special act, which governs the organization, the special act looks pretty much like this document, which is a book. You all have this book, which essentially is the state statute that created the hospital district back in 1951 and currently serving through 2007. And it essentially sets forth the duties and responsibilities of you as Board of Commissioners and the obligations of you in a public capacity. You also can adopt policies on a district-wide basis. You may remember just this past spring, back in March, I believe, maybe April, you adopted a revised fair market value policy that was driven by some significant analysis and review by your outside consultants along with administration and others to essentially provide that going forward in a robust effort to comply with federal law, federal requirements, and particularly in light of the pending subpoena, that you would in fact provide a fair market value policy which met those requirements. So you did that. In the matrix of compensation and the form of the contracts that you approved were compatible with that fair market value policy. When you made your decision in June to go forward in connection with embarking on the pathway to correctness and legality, you did so by directing administration to process those contracts, which was done except for the remaining 2, as I mentioned earlier. As you also know, and I regret to inform you that within 24 hours after having provided notice, legal counsel for Dr. Chizner advised this organization in a letter dated November the 5th that the district was in violation of its contract with the doctor and provides for a challenge litigation in the context of that decision. You've all been receiving, you've gotten copies of that letter from Mr. Lemieux, with whom we've had several conversations, and that is also a matter of public record. The November 5th letter sent to my attention and copied to you with regard to that matter. So you now have a federal investigatory subpoena, which is a highly serious document, which provides for very significant issues affecting this hospital organization. You've made every good faith effort to follow and comply with federal law and follow the advice of your lawyers, both locally as well as in Washington, principally your DC attorneys, and principally working on revising contracts and moving in a forward direction for that particular purpose. So, if I may, having had shade meetings on the subject, you know that there are some limitations on what you can and what you can't say, which I regret, unfortunately, is the way it is. The subpoena is what it is. It's a very broad-based document with some very significant implications.
I recognize the Vice Chair for,
please.
The other 2 pieces of legislation, federal legislation that involve the kickback and the
Start clause.
Start clause.
Yes.
That's another factor that we go on. It's relative to the law that we use.
And we've been advised by our lawyers in Washington about the application of both the Start clause, issues regarding False Claims Act matters, as well as anti-kickback and fraud issues. And that's the reason, as you may remember, why you assisted in engaging the Aaron Fox firm. You may remember also that Linda Bauman is the published author of the book, which is used in law schools throughout the country with regard to the subject. It's something which she's very familiar with and gave you that advice both in public and in private on a one-on-one basis and otherwise. So you've been following that guidance and direction. And today we get to this point, regrettably, or not regrettably, in the context of having received that specific legal advice. So today, just to recap, Mr. Chair and Commissioners, this is public comment. There's a whole agenda yet to come. You've not even begun, so to speak, with regard to other public business matters. But today, right now, for this particular item, it's public comment. People have a right to be heard. They don't have a right to be disruptive. They have no right to disrupt your meeting and to detract from the public's right of access to all of you and the public's business, which will be occurring on this agenda shortly. So, if I may offer, 3 minutes is typical. People don't get to roll over their minutes. You essentially have your 3 minutes to speak, unless the chair would prefer additional time for any one particular speaker. Your clerk of the board is Mary Ann Wing. She's been here for about 100 years, and she knows the process. She knows the process. She has a bell, which will help people to remember what 3 minutes sounds like and looks like. And if I can answer questions on any subject issue, I'll be happy to. I'll also advise you that for the record, Mr. Johnson sitting in the front row, he's the gentleman that can raise his hand, Bruce, if you will. With him is one of his law partners as well, Mr. Chris Stearns. Raise your hand, Chris. Thank you. And they were also able to help you. There are local labor and employment counsel that may be of issue if you have that need. So if that's the case, Mr. Chair, I'm happy to respond to questions. That's the framework of where you get to public discussion. And the statute that you're referring to is Chapter 286, which, as you know, is the Florida Sunshine Law. It's part of the Florida Constitution. People have a right to be in public meetings to air their views, whatever their views may be, so long as they're not disruptive or don't detract from the public's right to do business.
We have a court reporter here today.
You do?
Our court reporter.
I did not hire the court reporter. She's a very lovely lady, I'm sure, but she's here and she's taking notes. And what I'd suggest to you, just to keep the record clear, is to try to talk one at a time and not overspeak each other, because that'll probably be helpful to her and her fingers as well.
I'm used to being on the record.
Yes. And to the extent that I can answer questions during the course of the colloquy here, I'm happy to try.
So I have a suggestion, if everybody's in agreement. We'll start with George Lemieux. We'll give him additional time and deference to his representation of Dr. Chizner. But for everybody else, I hate to be a stickler, but I'm gonna stick to the 3 minutes, because we have 13 items on our agenda. I don't want to lose control of the meeting. I want everybody to be heard, but I gotta have some strict timelines and guidelines. If everyone's okay with that, we'll proceed in that.